Y'all, I am so exhausted. This mess has taken me everywhere from New York to California, Costa Rica, and ending things today in Texas. Drama. Hello, my fam. It is Perez, the queen of all media, the original influencer, and your number one source for everything. It ends with us. Saga. In addition to the federal lawsuit where they are both parties, Subpoena Serena and Jed Wallace are also simultaneously suing themselves in court in Texas. Jed Wallace is the digital social media expert hired by Baldoni's crisis communications team. The same person that the plantation princess accused of sexual harassment, even though he was never on the set of It Ends With Us. Colleen Hoover's bestie filed a motion to be dismissed from the litigation in Texas. Jed Wallace objected to that, and today she has filed a motion in response to his objection and asking nicely the court to let her go bye-bye in Texas. Why? They argue, despite rewriting their initial complaint and redesigning their original claims, plaintiffs still have failed to demonstrate that Texas is the appropriate venue or jurisdiction for their claims. It is not. Or that their defamation claim can survive their failure to meet basic pleading requirements and the multiple applicable privileges that bar it. As to venue, the first-to-file rule demands dismissal in deference to the New York litigation, which involves identical facts, witnesses, and questions of law. I just had something to eat. Additionally, they remind the court in Texas that the defamation claims against her have been dropped in New York. Plus, even if they could overcome the first-to-file rule, which they cannot, plaintiffs grasp at straws to establish venue and jurisdiction. Plaintiffs plural because she is suing Jed Wallace and his company, Street Relations. They argue the events giving rise to the alleged defamation for which she is being sued occurred outside of Texas. And Ms. Lively's prior Rule 202 petition, which was never even served, cannot support either venue or personal jurisdiction over her. As for the merits, the first amended complaint fails to state a claim as a matter of law, including because the statements at issue are protected by the same litigation and fair report privileges that the first filed court already found doomed the defamation claim of the New York Wayfarer plaintiffs. There is a little interesting footnote here. It says, the court dismissed the New York Wayfarer party's amended complaint in its entirety. So Team Delulu is saying, look, let's not even contemplate right now if this should play out here. Because a parallel case with the same issues and the same parties is happening right now in New York, and the court there just tossed it out with prejudice, meaning that in New York, they cannot bring up the defamation claims again, and reminding the court in Texas the reason it cannot be brought up again, and the reason it has no merit in Texas is she weaseled her way out of any defamation by legalities. The California Civil Rights Department complaint was protected. She could have said, Jed Wallace is a murderer. She could have said, Justin Baldoni killed 10 babies in front of me. And correct me if I'm wrong, but because of the venue, how she complained in that official CRD document to the labor board in California, that's protected. So defamation would not hold up in Texas like it didn't hold up in New York. And also, the New York Times was protected because of the fair report privilege. They were able to cover this official document, this official government proceeding. So far, they're making good points. She's got a different legal team in Texas. Her Texas lawyer is Laura Lee Prather from Haynes and Boone, LLP. Then they reiterate some of these talking points. There is substantial overlap between the New York litigation and this case. True. Another interesting footnote, plaintiffs, Jed Wallace and Street Relations, repeatedly point out that Ms. Lively added plaintiffs as parties to the New York litigation after plaintiffs initiated the lawsuit. They do not argue that the timing makes this the first filed case, nor can they because the rule does not require identity of parties, meaning at the very beginning of the first filed lawsuit. Moreover, plaintiffs ignore that the only reason they filed this lawsuit is because they knew Miss Lively was planning to imminently add them as parties in the New York litigation. Also, Texas is not the right venue. The events giving rise to the claim did not occur in this district. They cite relevant case law. The court lacks personal jurisdiction over Miss Lively. The CRD complaint is not directed at Texas. Plaintiffs fail to state a claim for defamation, so improper pleading. Also, they argue that the assertion that she alleged sexual harassment from Jed Wallace is unreasonable. And they add, plaintiffs have thus abandoned their implied defamation claim by failing to defend it. Plaintiffs fail to sufficiently plead fault. Plaintiffs fail to sufficiently allege defamation, which means they must have failed to plead damages. The CRD complaint is privileged under California law. Plaintiffs concede that the litigation privilege protects the statements in the CRD complaint. The common law and California Fair Report privilege protects any sharing of the CRD complaint to the media. That was an important part I did not bring up earlier. Remember, Diva Pool had months and months to plan and prepare, strategize, think of every scenario before everything. So that gave her an advantage, definitely. Additionally, they argue the sexual harassment privilege protects Miss Lively's statements. And in conclusion, Miss Lively respectfully requests that this court dismiss this case with prejudice and award her attorney's fees. All right, let me take a minute and I'll get right back to you. I'm going to ponder this. Shout out to Laura Lee Prather, who put this together. Much better than Mike and Ezra, in my opinion. Laura did very little drama and just boom, boom, boom. Concise, fact, relevant case law. This is what's happening here. This is what's happening there. And this is why the court should rule this way. And I agree with Laura. Having read this, I think this is going to be a win for her. What do you think? How should the judge rule? Take your dislike or potential like. Leave your emotions out the door and just look at what is being presented and the law as we know it. How should the judge rule? Let me know in the comments section.